Thank you, Mr. Chairman. Congratulations to each of you. Ms. Hill, what is collateral estoppel?
Collateral estoppel. I think collateral estoppel, well, Senator, I will say that my 20 years of practice has primarily been dealing with issues relating to criminal law or relating to other areas of the law.
Yes,
and
ma'am. If you don't know, just tell me.
I certainly do know collateral estoppel. I'm finding that the bright lights of the moment are making it hard for me to recall it.
Okay, so you don't recall it. Okay. What is the amount in controversy requirement?
The amount in controversy requirement is $75,000. It typically governs, in many cases, almost any case in diversity jurisdiction in the federal courts.
Okay.
And a certain other.
What does the 13th Amendment to the Constitution do?
It outlaws slavery.
What does the 7th Amendment do?
It ensures that all civil jury trials, that all civil cases in the United States are done by jury trial. That you have a right to a jury trial in a civil case.
Okay. What is the difference between a stay order and an injunction?
A stay order would prohibit, an injunction would restrain the parties from taking action. A stay order, I'm not sure that I actually can give you the.
Okay.
That.
Tell me about, you'll see a lot of this in federal court. Tell me about the multi-district litigation statute.
So I'm not extremely familiar with the multi-district litigation. I do know that multi-district litigation is often consolidated into a particular court. So all of the cases involving a particular type of issue, if there is a multi-district litigation, those will all be referred to one court and one judge who will then oversee the MDL. But I will confess I'm not super familiar with all the ins and outs of that.
Okay. What kind of constitutional claims are subject to intermediate judicial scrutiny?
Cases involving certain types of classes, such as gender or illegitimacy, are subject to intermediate scrutiny. Some types of speech, like commercial speech, would be subject to intermediate scrutiny.
Okay. Tell me what a 12B6 motion is.
It's a motion to dismiss a claim, a motion to dismiss an issue for failure to state a claim.
Okay. And what's the standard for granting a summary judgment in federal court?
It says that there are no issues of material fact and that the issue can therefore be decided as a matter of law.
Okay. What's the standard for deciding whether a particular punishment is cruel and unusual under the 8th Amendment?
So the particular standard the court has said, and I cannot recall the case, but it says that you have to look at not only whether it is would be shocking to the individuals at the time that it was written, so it's not purely a historical review, as some of them are purely historical, but also you have to look at how it has changed, how those values have changed with time. It's one of those circumstances where the court says it's appropriate to look at how values have changed with time.
Well, our right against cruel and unusual punishment is a fundamental right, is it not?
It is.
Okay. How do you
Senator John Kennedy doesn't pull any punches, and today was no exception. In a confirmation hearing that felt more like a lightning round bar exam, Judicial Nominee Sarah Hill faced an unrelenting barrage of rapid-fire legal questions. From constitutional amendments to civil procedure, it was a legal obstacle course on full display before the Senate Judiciary Committee. This is Voice of the Capitol, and this is how a Senate hearing became a test of legal endurance.
Thank you, Mr. Chairman. Congratulations to each of you.
But within seconds, Senator Kennedy fired his first shot.
Ms. Hill, what is collateral estoppel?
Ms. Hill hesitated, clearly struggling under the pressure of the moment.
I certainly do know collateral estoppel. The bright lights are making it hard for me to recall.
Not a great start, especially when facing Kennedy, whose pointed legal queries have become something of a Senate tradition. One question led to another. The amount in controversy? She got it right, $75,000. The 13th and 7th Amendments? Also correct. But when Kennedy dug into the difference between a stay and an injunction, Hill fumbled again. Then came the big ones: multi-district litigation statutes, intermediate scrutiny, motions to dismiss, cruel and unusual punishment under the Eighth Amendment. It was a full tour through federal civil procedure and constitutional law. Despite some correct answers, Hill often stumbled, qualified, or flat out admitted a lack of clarity.
How do you square what you just told me about the Eighth Amendment with the case after case after case by the U.S. Supreme Court that says the definition of a fundamental right is one that's explicitly stated in the Constitution or deeply rooted in our history and tradition?
Yeah, I think that it is. I think it is deeply rooted in our history and tradition.
Yeah, but certain forms of punishment are not. If a form of punishment, it existed at the time of our founding, and it's deeply rooted in our history and tradition, you telling me that makes it automatically constitutional today? I thought you just told me.
No, I'm certainly not saying that. I'm not. What I say is about it is really quite irrelevant, but the Supreme Court has said we look at it with a view to the changing values on these issues.
Why the difference? I thought
they're
both fundamental rights. Why the difference?
I think that's a question that the Supreme Court's going to have to answer, whether or not they have.
I think it has. I'm just asking if you know.
The message was clear. If you want a lifetime appointment to the federal bench, you'd better be ready for the test, even if it feels like it's straight out of a law school final exam. What did you think of Miss Hill's performance? Was the questioning fair or too aggressive? Drop your thoughts in the comments. And don't forget to like, subscribe, and hit that bell for more in-depth coverage of America's political front lines. This is Voice of the Capitol, where the truth speaks louder.